our Inside Innocence brunch edition. I'm going to give people a few minutes to just join us. And if you're here, go ahead and let me know. I'd love to see who's joining us today. Vilma and Mary, thank you so much for joining us. I really appreciate it. Really excited about today's topic. It's very timely and affects a lot of people here in Florida. So, let's see. We're so happy that everyone's decided to spend their brunch time with us. Hi, Cindy. Welcome. We're so glad that you're here. And Sadie, thanks for joining us. We appreciate you. Hey, good morning, Chad. Morning from Parkland. Just gonna give it just a couple more minutes. Oh, hi, Linda, or Lynn, sorry. Thanks for joining us. This is our third edition of Inside Innocence. I feel like we're, getting the feel of it. Things are going well. We have a lot of fun topics coming up. So I just want to say welcome again to this brunch edition of Inside Innocence. And I'm so happy to have you all with us. I'm Kelly Helm, the development coordinator here at Innocence Project of Florida. Hi, Sharon and Lenny from Coral Springs. Thanks for joining us. Getting people from all over the state. Let's see. So we'll wait just a few more minutes. Hi, Terry. Nice to see you. Hi, Jeff and Becky. Thanks so much for joining us again. It's always great to see you guys. David Moran from St. Pete. How is another day in paradise? Hi, Jenny from Panama City Beach. Thanks so much. We still have just a people joining us online, so just gonna give it a couple more minutes. But while we do let more people join us, I want to tell you about the talk that we have upcoming. On Tuesday, we will be hosting an educational session of Inside Innocence with IPF intake coordinator, Dr. Gina Thompson. She talks about the factors that affect eyewitness identification and how Florida law can work to protect the innocent from mistaken identifications. So expect some science, storytelling, and time for questions. And that's on Tuesday. 2 p.m. Again, it'll be a Facebook Live event, just like you're attending here. And Dr. Thompson will be going into in depth about mistaken identifications and what goes into it. And it's very interesting science and factors into a lot of our cases here at IPF. Still just letting some people join. Hi everybody. Good morning, Jessica. Thanks for joining us. Jessica in Tallahassee, local here to us. So we're just gonna give a few more minutes for people to keep joining us, but I wanna introduce our speakers for today. So we have IPF's Executive Director, Seth Miller, and clemency and parole expert, Reggie Garcia, joining us for a live discussion of the pandemic in prisons and direct actions that can be taken to lobby for the release of an inmate. So Reggie Garcia is a Tallahassee local, just like Jessica and Seth and me. He is considered to be one of Florida's most experienced executive clemency lawyers, and for the past 25 years, he has represented prisoners and people with felonies before 4 eras of Florida governors. This representation includes helping clients to obtain waivers, prison commutations, full and conditional pardons, firearm authority, and restoration of civil rights. Reggie is the author of 2 books that serve as guides to navigate the Florida State Prison Clemency, Parole, and Work Release programs. Thanks so much for joining us, Reggie, and we are excited to have you here with us today. We also have Seth Miller, who has been IPF's executive director since 2006. He litigates post-conviction innocence cases, supervises IPF's internship program, and regularly lectures students, lawyers, and community groups on issues related to wrongful convictions. Seth also teaches as an adjunct professor at Florida State University College of Law. He recently completed a 5-year term as president of the Innocence Network, a consortium of more than 70 innocence organizations in the United States and abroad. And we're excited to hear from you both. Welcome.
Hi, Kelly. Thanks. It's great to be here, everyone. Reggie, thanks for being here on this Sunday morning with us. I know we'd all rather be outside working in our gardens or in the pool or at church or somewhere else, but we appreciate everyone joining for this, what I think is a really important Inside Innocence program. At the Innocence Project of Florida, we're one of the few organizations that represents prisoners from an organizational perspective. We're in Florida's prisons, and as you can imagine, we've been getting a lot of phone calls and emails and social media inquiries about how folks can help their loved ones who are trapped in jails and prisons where COVID-19 might be spreading. And so in light of that, we wanted to have a really good in-depth discussion about the impact of the virus on this vulnerable population of people, but also try to give people, those loved ones, some guidance on ways, as limited as they may be, that they can help their incarcerated loved ones in this time of public health crisis. So Reggie, Kelly gave an introduction to your practice, but I was hoping we can hear from you and you can describe your practice a little, help us understand what clemency is, and also describe who the Commission on Offender Review is.
Sure, and thank you for having me, and thank you for all the terrific work the Innocence Project of Florida does, doing litigation and appeals and other post-conviction proceedings to actually get innocent inmates out of prison and at liberty. And all of our dear friends, God rest his soul. I always think of Sandy D'Alembert, the former FSU president and law dean, who had the vision, along with others, to found the Innocence Project. And Seth, for your and your team's leadership. Executive clemency, which we frankly hear more about on the federal level, but every state governor has that power. Here in Florida, it's the governor of Florida's prerogative and power, and it's an immense power to grant mercy under the Constitution. And if the governor says yes, you need 2 other members of the Florida cabinet to agree. Completely separate than clemency, of which commutation of prison sentences is one type, is called parole. And for many years, we had the Florida Parole Commission. It's now called the Florida Commission on Offender Review. And the legislature abolished parole in 1995. So there's about 4,500 state inmates in various stages of parole eligibility. So the 3 commissioners of the Florida Commission on Offender Review, most importantly, do clemency investigations, also do direct parole for those pre-95 convictions. And then what we'll talk a little bit about today, they have another immense power called granting conditional medical release for state prisoners that are either terminally ill or permanently incapacitated.
Okay, so it's a lot of meat there, and we're going to get into more about how both you and people who are advocating for their family members will intersect with the Board of Executive Clemency and the Commission on Offender Review. But before we do that, I wanted to sort of set the stage by giving us a little bit of information about COVID-19 and talk about how it's impacting jail and prison facilities. So look, we all know what this virus is right now. We've been staying in our homes, many of us for 7 weeks now, watching the news, reading articles on the internet about it. But we know that the virus can cause severe flu-like symptoms. And for those that suffer and die from it, it creates, debilitating pneumonia. It attacks your lungs. It can also attack other organs like your heart and your liver. And interestingly enough, we've just found out there have been reports of strokes in young people, even ones who don't otherwise have your typical symptoms. We also know, unlike the flu or even other pandemic-like conditions, this is highly contagious. And one of the reasons it's highly contagious is because, unlike other conditions where you have to be showing symptoms to be able to spread it to someone, most people don't have symptoms yet are highly contagious, and they can spread it to people unknowingly. So it's hard to keep track of. We've also learned key things in this time that can be done to prevent the spread of the virus. Very simple things. Wearing masks. Everybody has these, a lot of people have cute masks now made out of cloth that have their schools or whatever on them. We know that hygiene is very important. Consistent washing of hands, using hand sanitizer, not touching your face, which is very difficult for lots of people, including children. And most importantly, social distancing. We've all had to stay in our houses. We know that when we go to the grocery or go out in public where we have to do something, we want to stay 6 feet or more away from people, not congregate in large groups of people. Even though we have been doing these measures as a public to one degree or another for 7 weeks now in the United States, we still have had 1.16 million positive cases in the United States and its territories and in other places run by the United States government. And unfortunately, that's led to 67,500 deaths roughly as of this morning. And hotspots are often cropping up in places like nursing homes and assisted living facilities because these are closed communities where hygiene may not be the best, and also social distancing is not as possible as it might be in other places. Another place that social distancing is hard, and some of these measures we might not be able to take them, are jails and prisons. And so this is a closed community, the most closed community, and many jails and prisons are overcrowded. And what we've seen just in the last many weeks is that in many jails and prisons around the United States, once COVID-19 has gotten into the prison, either because an inmate who is just admitted brought it in, or a staff member who works there but is otherwise, when they're outside of work, living in the community, has brought it into the facility. And in many places, it's spread like wildfire. We've seen examples in Ohio where the Ohio Department of Corrections has done mass testing and found almost 4,000 positive cases in the Department of Corrections there out of 5,700 tested, which is a 68% positive rate. That accounts for 22% of all, including the general public, all of the positive cases in Ohio, and they've had 29 deaths in the Department of Corrections, and they have an additional 37,000 inmates in medical quarantine. In Cook County, the jail in Chicago, 490 prisoners and 342 staff are positive, with 6 prisoners and 1 staff member having died. In Rikers Island, the jail used main jail in New York City, the rate of infection in the jail is 5 times that of New York City generally. And we all know that New York City is, or has been, the hottest of hotspots in the United States, with the most positive cases and the most deaths. And the way this has sort of impacted Innocence organizations is that in Pennsylvania, the very first inmate prisoner to die in the Pennsylvania Department of Corrections was a gentleman named Rudolf Sutton, who was a client of the Pennsylvania Innocence Project, and his case was being reviewed by the Philadelphia District Attorney's Conviction Integrity Unit at that time to determine whether they were going to agree to overturn his conviction and exonerate him. And he had spent more than 30 years wrongfully incarcerated at the time of his untimely death. And so then the question is, how does this manifest in Florida's Department of Corrections? And Florida has about 100,000 people in prisons all across Florida. And they've only tested, this is as of Friday, they've only tested 735 prisoners, 208 of which had tested positive, and they have another 170 tests pending. They have 146 staff members who have tested positive, and almost 3,600 prisoners remain in medical quarantine, which, according to the Department of Corrections, means that they're either showing symptoms of the virus or had contact with a prisoner or staff member who's tested positive. And some of the particular hotspots, which for folks who are on this Facebook Live, you might have family members there, are Tomoka, CI, South Bay, Sumter, Gadsden, Blackwater, and we were having a conversation before this, Reggie and I, and he alerted me that Liberty Correctional and Columbia Correctional are maybe rising hotspots, if you will. So this is what's going on. And at the Innocence Project of Florida, well, we represent innocent people and we do litigation to get them out. We're trying as much as we can do in this limited environment where the courts are only partially open to get our clients out of prisons. We felt that because of our standing in the criminal justice system, we needed to do something to advocate for better measures to keep everyone in prison, both prisoners and staff, safe in this time. So on April 3rd, we issued a letter to the governor, to Governor DeSantis and Secretary of Department of Corrections, Mark Inch, and we issued 15 recommendations in the letter for how they can address issues related to this virus. And they really fall into 4 specific areas. The first was identifying the extent of the prevalence of the virus. So basically, you need to do more and consistent testing in order to understand the problem that you have. We wanted to provide for release of prisoners in jails and prisons who are low risk due to either their age or their offense, or they're near the end of their sentences. We don't want them to get sick right before they're going to get out. And the idea being that this will release overcrowding that makes it impossible to even make a good faith attempt to socially distance. We wanted to provide greater access to hygiene products like soap and hand sanitizer and personal protective gear like masks so that they can prevent the spread of the virus. And of course, give staff paid sick leave so they don't feel financially compelled to come to work when they're sick and showing signs of the virus. And lastly, transparency. At the time we issued the letter, the department did not have public statistics of COVID-19 in their prisons. They've since put up a website. And so while we didn't get a response, naturally we didn't think we would, from the powers that be, there are a number of things have been implemented. Our clients are telling us that they do have access to soap and hand sanitizer for free, which is important. They have been giving masks in many of the prisons, which is great. There have been limitations on movement inside the compound and quarantining of those that have had contact with someone who tested positive. They are screening staff and new inmates as they come in the facilities, and they are updating their stats daily. But we're still a ways to go. There was and probably still is a lack of full transparency. It's been through media reporting that we found out that there was many thousands of people in the Department of Corrections who were in medical quarantine. We didn't know that existed until the Miami Herald reported it, and now it's part of the daily stats that are updated. We know that in counties, the sheriffs and state attorneys have moved to, in many places, to release people who are low risk, but that is not happening in the same extent in the Department of Corrections. And we also know that less than 1% of the population of the DOC has been tested. And given what we know, based on the other things I've told you about the spread of the virus in jails and prison facilities, it's likely that more people in the prison have it than we know about, because there's just not the amount of testing. So this sort of gives you a sense of where we're at currently. And so again, while we're doing at the Innocence Project Florida as much as we can within the courts to get our clients released, there are other non-litigation methods to sort of be able to try to get our loved ones, our family members, our clients out of prison to get them safe from this medical crisis. And that's what we're here to talk to Reggie about today. So Reggie, you read our letter, you emailed me when you saw it. And I just want to know, one, when you read it, what you thought about it, but also what did it make you do after you read it?
Yeah, and thank you for doing that. It literally inspired me because I had written a legal article 5 years ago, as well as a book chapter on conditional medical release, I almost immediately started asking for updated data from the Commission on Offender Review and updated that legal article, which includes what I call the 17 how-to steps to assist family members, advocates, lawyers, others, people without lawyers, frankly, for the roadmap of how to do conditional medical release. So it prompted me to do that. And then once I had the legal article written, I shortened it into what's called an opinion editorial under 600 words. And thankfully, 4 papers that I'm aware of: Tampa Bay Times, Fort Myers News Press, Florida Today in Brevard County, and here Tallahassee Democrat, published that opinion editorial, which has led to, I think, an increased awareness, because I've gotten calls and emails from legislators, but also, frankly, from loved ones with inmates that in prison that didn't know anything about conditional medical release, much less how to do it. And then some of that information has been included in news articles. So you all kind of lit a fire under me, and hopefully I just added a little bit to what the written material is out there and dialogue, which hopefully is inspiring others. But you made a very important point. The public usually doesn't make a distinction between local jails, which, as you pointed out, are run by our sheriffs, state prisons, which we have 57 major prisons, but a total of 144 state facilities called annexes, camps, community release centers, and then federal prisons, of which there's approximately 150,000 people nationwide, but 9 federal prisons in Florida. So on the one hand, the local jails are letting, I think, appropriately, nonviolent people who have been arrested who just haven't been able to post bail out so that they don't get COVID and in turn infect the correctional officers who infect their families. And then on the federal level, as I understand it, under the Bureau of Prisons and the Attorney General's guidelines, either wardens or the federal judges have released about 1,500 federal inmates. So when Michael Cohen or a former congresswoman gets released, of course, people read about that in the newspaper, and they don't immediately draw the distinction that that's a federal inmate. They just know they have a loved one in state prison and want to know, what, if any, options are there for us to help them.
Yeah, and so for folks who don't know, Michael Cohen being the president's former private attorney who's now in federal prison, I think they actually took away his release, so he's going to remain there. So thank you, Reggie, for that. You mentioned a legal article that you wrote and some op-eds, and I just wanted to let the folks who are on the Facebook Live know that we're going to be posting those items to our website, so they're easily available on our Inside Innocence webpage, so people can go look at them after. We're going to discuss them, but you can look at them and read them in more depth afterwards. Reggie, I know that you had a number of recommendations in your legal article, and I think we want to kind of boil down to 4 potential avenues of release that you've identified, that might be reasonable avenues of release to think about as it relates to COVID-19 and someone's loved one in prison. So if you want to identify them, and then we can go through them one by one and try to learn more about them.
Sure. Executive clemency, as good as it is, if someone's got a pending application to commute a prison sentence, then that's certainly one option, is to try and get that going faster. But again, clemency in general and commutations take a long time, and you ultimately need the governor and 2 cabinet members. So it's not fast, and it's not the best option unless, frankly, it's already been pending and toward ready for consideration. Parole, as I mentioned, was abolished in 1995, but there are approximately 4,500 inmates in various stages of parole eligibility. And the Parole Commission, which is now called the Commission on Offender Review, is literally meeting weekly by phone to consider those cases. Work release, we have about 8,000 inmates at 35 facilities who are in various stages of work release. That's a good thing. They're out in the community, they're working, they have community custody, and they in turn are further eligible for certain short-term furloughs. And then I think most applicable are conditional medical releases. The last 25 years, there have been about 346 of those. So give or take 14 or 15 a year, not a lot, but it's better than not doing any. But I think what people are urging is the Department of Corrections, that has the power to make an immediate medical diagnosis of an inmate who's either terminally ill, meaning they are likely to pass away in the next 6 months, or, and it doesn't have to be both, or what's called permanently incapacitated, and they're putting that definition up on the screen. Both of those have some inherent discretion and subjectivity, and that's a good thing. So I think what we want our legislators and policymakers and nonprofit groups and innocence groups to encourage our state legislators, but most importantly, encourage them to encourage the Department of Corrections to potentially do more short-term conditional medical releases, given the COVID virus spread, and especially the vulnerability, you said, to older inmates who may have chronic illnesses and lung or respiratory ailments or diseases that would make them more vulnerable.
Okay, so let's try to pick those apart a little bit. I mean, I think we have time and space to go into a little bit more depth, and we'll get to conditional medical release last, because I think that is the meatiest area and maybe the most potential area here for release. And so, just briefly on furloughs, I know that you had told me that you did some look at the furlough statute. It's a little bit confusing, but we're talking about furloughs. Who are we talking about that might be eligible for a furlough, so that people who are listening to this can know right away whether their family member might qualify or not? Sure,
and of course the same word is being used sadly in the employment context to mean hopefully temporary suspensions of employees, meaning to no fault of their own. Disney World furloughed 77,000 people. The concept in the state prisons is there's a rule that says if you're community custody, meaning one of those 8,000 people on work release, or what's called minimum custody, one of those inmates, and that's right there on the DOC website, but of course loved ones know the custody level of the inmates. Pregnant women being let out on a short-term basis to deliver a baby. That seems like a no-brainer, but that's historically been an option. To visit a dying relative, to attend a funeral, for short-term rehabilitation or work release reasons. Those are considerations, and there's two very simple forms that the inmate has to fill out, and then a sponsor, either a local law enforcement official or a family member that in effect is going to take responsibility for the inmate and make sure they get back to prison at the end of the furlough. Some are as short as for 1 day, others are for 6 or 8 weeks, depending again on what the reason is. So I don't want to downplay that, but that's not going to help the most people, because most current inmates, particularly who have chronic medical issues, if they had serious convictions, might have what's called close custody or medium custody. Thus, they don't qualify for a furlough, because that's limited to our least serious inmates who have minimum or community. So that covers furloughs, and all of that is internally done by the Department of Corrections and has to start with the inmate himself or herself. And you think of this vast bureaucracy. We've got about 93,000 state inmates at 57 major prisons. You mentioned several of them that have the testing hotspots, but there's a total of 144 state prison facilities. Contrast that with our 67 county jails that are run by our sheriffs, and they're the sheriffs in consultation with state attorneys, I think for the most part are doing the right things and letting people out who otherwise may not make bail, who, by the way, haven't been convicted of anything. And then there is a small group of folks in our jails that are serving sentences. They've pled guilty or been found guilty. They're serving short sentences of 1 year or less. And then federal we talked about. But yeah, furloughs are an option for state prisoners, and I think you all are going to post those forms on your website. But essentially that needs to start with the inmate at the facility and then the inmate's family members to ask for that. But those are very short-term releases and honestly not that prevalently used.
Thank you. And so, one of the places where I see you, Reggie, around town is at the Commission on Offender Review. You might be there a little more than I am, but we have a number of clients who are representing in court on claims of innocence, but who, because of the age of their cases, are parole eligible because their offense occurred when parole was still in place. And so I'm over there sometimes as well. And so I guess if you could give us a very brief description of how parole might be at this moment in time, those proceedings might be available to, and how, particularly in light of COVID-19, might be available to obtain someone's release on parole conditions.
Correct, and to remind everyone, parole was abolished by the legislature in 1995. So those less than 5,000 inmates out of almost 100,000 are in various stages of parole eligibility. They have an initial hearing, then a few years later they have a subsequent hearing. The most important factor is, are they good inmates? Are they not getting what are called disciplinary reports? Are they a low risk to reoffend? And if the answer to that is yes, our 3 parole commissioners refer them to special reentry programming at 4 or 5 of our facilities. So if they're already in that queue, and especially if they're toward the latter part of that, many times they're referred to what's called Everglades CI in Miami-Dade County for parole reentry. And if they are already parole eligible and there's a medical issue, and in light of their age and COVID, I think it will be another factor that is considered, but not the only factor.
Do you think that, like I know, for example, they set hearings sometimes 5 or 7 years in the future from the last hearing. Do you think in light of the pandemic, its existence might be a reason to ask for another special interview in the interim, particularly for someone who has medical conditions that and is on a good track for release anyhow?
Yeah, and that's where we're starting to blend the discussion of regular parole, whether or not there's medical issues or not, and they're certainly not mutually exclusive. But absolutely, the main 3 decisions they make at every parole hearing is, when are we going to hear the case again? And it could be as short as 2 years, which is a good thing, meaning they think that person eventually is going to be paroled, or as long as 7 years. And if they say 5, 6, or 7 years, usually because there was a very serious underlying conviction and the inmate has not been a good inmate, that's their way of the parole commissioners saying, we don't want to drag the state attorneys and the victims back to Tallahassee for a hearing in the short term. So that's their way of saying they don't think that's a good parole eligible case. And then for the ones that they do think are parole eligible, they refer them for special programming. In this case, because they're pre-95 convictions, the inmates have served 30, 35, in some cases 40 years, and by definition have not been at liberty, and the entire world has changed, not just technology, but everything else. So these reentry programs to prepare someone for potential parole accomplish that transition.
Okay, and so it seems like for someone who is already in the queue and has a number of these boxes checked, good disciplinary record, has a potential release date that is sort of in the near term, they might be a good candidate to ask the parole commission to consider an interview, maybe shorter in time, because if they're going to get parole, we want to make sure they get there and they don't get this virus and have a debilitating condition.
That's right. I think it becomes one other factor. The thing that I think has the most procedural potential in the short term, and honestly almost immediately, is if an inmate is terminally ill, aside from whether they are or not eligible for parole, and for the people whose convictions have occurred since 1995, then by definition they're not eligible for regular parole. But for everybody else in prison, if they're terminally incapacitated, and keep in mind, we have hundreds, if not thousands, of inmates in their 70s and 80s and sometimes older who committed crimes long ago. They're not a risk to reoffend. Zephyr Hill State Prison, just by way of example, north of Tampa, has seniors and elderly inmates who are nonviolent and are candidates, I think, for conditional medical release. But it's very important that the Department of Corrections consider someone who's either terminally ill or permanently incapacitated for, in effect, an expedited conditional medical release.
Okay, and we'll get to that in a second. I have one more, and it's Stacy Schrader asked on Facebook, can you ask for an extraordinary review if not scheduled for review this year? And I think that's what I just asked. And I think the answer is yes. You can ask for one. I just think people need to be realistic about the or the Commission on Offender Review giving it to you or not.
Yeah, and that's a special, unique type of hearing at the Commission on Offender Review for what I would call regular parole eligible inmates who may be in between hearings or one's coming up, but it's not for 6 months or a year. And given the COVID situation, and particularly if it's an elderly inmate who's nonviolent, who's parole eligible anyway, and you add some medical chronic illnesses, which may or may not rise to the level of being terminal, again, I don't think it hurts to ask the Parole Commission, in effect, to do a faster, sooner interview. I'm just not aware how many of those they're doing, but I think they would consider those on a case-by-case basis.
Yeah, and before we move out of the parole, I just want to add that, while courts, for example, have been mostly, I find them mostly dysfunctional since the pandemic set in. They're only doing there are no in-person hearings and only doing hearings that can potentially lead to immediate release, bond hearings, pleas, things like that. The Commission on Offender Review, Reggie, am I right that they're meeting every week still remotely?
Yes, and they have a terrific website. And for some older folks like me, they'll wonder, well, who in the heck is the Commission on Offender Review? Think of them as the Florida Parole Commission, which has existed since 1941 with a new name, because they do more than just parole. They do clemency investigations. We haven't talked about, but what they do regular, what's called conditional release, meaning if an inmate has earned 15% gain time, they can get out having served 85% of their sentence. And that's a good thing. That's a state law, but it's implemented by DOC and the Commission on Offender Review. It's basically back-end probation for the last 15% of someone's sentence if they've earned the 15% gain time. So they do meet weekly on Wednesdays, and I believe they are meeting continually by phone. I don't know whether they've, from a technology standpoint, added audio. My gut is at some point when state government reopens, and we're not there yet for full-blown public hearings, that they may resume in-person hearings on Wednesday in Tallahassee, but just have, only a handful of people in the room at a time, along with the regular social distancing guidelines that the governor's outlined for restaurants and retail.
So when you mentioned clemency, and that's kind of where I wanted to go next, you admit, my understanding of clemency oftentimes is that, it is the ultimate act of mercy. We'd probably be talking about in this context commutations, because people are really looking for relief from their sentences. But the Board of Executive Clemency, as I understand it, doesn't meet all that often. And the question for you is, are they meeting now?
Well, they meet quarterly, March, June, September, and December. They do approximately 80 cases a quarter, keeping in mind that all of those have been investigated by the Commission on Offender Review. The inmate's been interviewed. In the case of someone who's already out, the former defendant and convicted felon is interviewed. A report is put together, an advisory recommendation. And then under the state constitution, you need the governor, he or she, to say yes. If the governor says no, it's no. If the governor says yes, two other members of the cabinet, the attorney general, the chief financial officer, or the commissioner of agriculture, have to join for any type of clemency, including a commutation. The March meeting, understandably, was delayed and postponed till April. The April meeting was postponed. I assume the April meeting will now become the June meeting, and that they will at some point reinstitute, when we're ready, live hearings in the cabinet room. Until that point, we're hopeful that they will be done by phone or audio, but we don't know that yet. But June, I think, would be the next earliest clemency meeting.
So if I understand you, though, unlike some of these other potential avenues, clemency is not a quick one. That right? I mean, it's something that is going to take both months in a normal or longer in a normal context, and in a context here where the cabinet is not meeting regularly, it may not be that great of an avenue for some emergency, more immediate release.
Correct. It frankly takes years and years because of the backlog and the investigation that's done to even get a hearing for a commutation. So yeah, that is not a good short-term option. The only workaround, if you will, is the clemency rules do provide something called Rule 17, and it literally says one sentence, and I'm paraphrasing, but in cases of exceptional merit, the governor or any member of the cabinet, meaning any of the 4 statewide elected officials, could expedite a clemency case, including a commutation case. So in theory, that procedurally is available for a current state inmate who has either already applied and is in the queue, or has very extraordinary circumstances coupled with medical, and would try and get a clemency case expedited. But yeah, in practice, that takes many, many years. And in the short term here, until state government fully reopens, those hearings aren't being done at all.
Okay, so that takes us then to conditional medical release. You've mentioned it a couple times, and I want to go into a little bit more granular detail about it, because it does feel like not only is it something that might be able to have the most immediate impact in terms of an avenue for relief, but it has, I think, the greatest connection or nexus to the current health situation that we're in. And so if we can, I want you to go through these sort of definitions that are key to conditional medical release. You had mentioned them: terminally ill and permanent incapacity. I know we have some slides, maybe we can put those up. And just if you can go into greater detail and discuss those so we can figure out how this works.
Sure, and it's exactly what you would think about from a common sense standpoint. And just for the terminology, because it took me a while to get this, some states call this compassionate release. Some states call this humanitarian release. Some states call this elderly release. Florida, the law literally calls it conditional medical release, because that's exactly what it is. The good news is it's not limited to just elderly inmates. So if you're 40 or 50, but God forbid have a terminal illness or a permanent incapacity, this is available to you. If you're in your 60s, 70s, and 80s and are elderly, but have one of these medical diagnoses that you're terminally ill, going to pass within the next 6 months, or permanently incapacitated, and as you'll see, those definitions are somewhat specific, but more guidance and imply some inherent discretion and subjectivity. So I think the challenge and the goal is for all of us to encourage the Department of Corrections to use these existing laws, this existing power. It doesn't require the legislature coming back to Tallahassee. It doesn't require a special session. It doesn't require a clemency. It doesn't require a parole. Literally, under current law, if your loved one meets one of these 2 definitions, or you think they do, or they met this definition before they even went into prison, and you could get a letter from a physician that said, as of 2 years ago, as of 5 years ago, this was their medical situation, they had this chronic illness or disease, then that's the starting point to really educate the DOC officials. And I think we're going to really talk about 4 specific steps on how to do that. And our goal is, and our hope is, that the DOC, from a humanitarian standpoint and from a compassionate standpoint, whereas 3 months ago they would have looked at an inmate and said, not dying within the next 6 months, chronic illness, but not a permanent incapacity, so we don't refer that for potential release. Now they look at through the COVID-19 lens. If this inmate who potentially is terminally ill or potentially permanently incapacitated gets the virus, and they have a pre-existing respiratory issue, lung issue, we now know, as you alluded to, propensity for strokes, or even heart or liver or other conditions, will it then, if they get the virus, make them terminally ill or permanently incapacitated? And if the answer to that is yes, or even maybe, then let's do a referral to the Commission on Offender Review so they can consider that specific inmate, his or her current medical condition, and his or her potential more aggravated medical condition if they get the virus.
Right. So I think that's what you just said is really important, because this requires the Department of Corrections to use a new lens through which to view this vehicle. And I think in order for them to do that, people need to be pushing them to do that. And that means the lawyers, the advocates, the loved ones who are advocating on behalf of people in prison, men and women in prison, need to continually push the Department of Corrections to not view this as just this person's going to die of cancer, but rather this person has a condition that we have an outbreak in the prison. If they get this, they're more likely to die, and we're going to have to take care of them on the way towards morbidity. So I think this leads then into the 4 steps that you alluded to, which really are things that, and they seem like simple things that people can do to advocate and agitate for their loved ones within the bureaucratic structure of the Department of Corrections to push for conditional medical release. And so, Reggie, I'm hoping you can go through these. And I do want to just ping for you. We do have a question about getting a medical diagnosis that when we get there, I'll ask it because I think it's a relevant question. So why don't you go ahead?
Sure. And they are on the screen. They would make common sense. We've kind of talked offline about the often used, but I think true saying, the squeaky wheel gets the grease. And what do I mean by that? We have 93,000 inmates in 144 facilities and 24,000 employees at DOC, of which 15,000 of those are correctional officers. The other 9,000 include everybody else, including the medical professionals, the classification officers, the chaplains, the food service people, everybody that it takes to run essentially a mini city or mini town, which is what each prison is with 1,500 to 2,000 inmates. So as simple as this sounds, writing a regular letter to the warden and putting a stamp on it. Why do I say that? Because it may take a week or 2 to get through, but they're going to get it. Eventually, that warden is literally going to get that piece of paper. They're going to open it, they're going to read it, and hopefully it's going to get their attention. Also, do an email. Every warden's email address is on the Department of Corrections website. And call the inmate classification officer and the warden. Not one of those things, but all of those things in concert with each other. Think about that. If you're the warden and you get 200 emails a day, you may or may not even see it or open it or understand it or access it. Or you may look at it very quickly and refer it to a staff member. But if you get a paper letter and you get an email and you get a phone call, and all of those things are possible. And I'm not saying this is easy and you may have to try several times to get through, but then there have been 3 contacts. Then that warden, he or she, I think, is going to ask their classification supervisor and their medical director, hey, please take a look at Joe Smith. He came in 2 years ago with a liver condition, a heart condition, an upper respiratory lung condition. He or she is missing or has a compromised spleen. Now they've gotten worse, and now COVID potentially is a death sentence for them. Likewise, contact the medical director at the prison directly. Each one of them has a medical director. We privatized medical, so the medical professionals, for the most part, in the individual prisons are medical contractors. I believe the company is called Centurion, that under a contract with the Department of Corrections provides that frontline medical care.
Reggie, about medical, because we have a question from Connie. She's asking, how can a doctor deny someone without having available medical records? And I think this goes to a key question. I mean, obviously, as someone, when they come into prison, they don't come with a medical file with them, right? From their life outside of prison, and so how does one go about getting a medical diagnosis that would fit them within the criteria in the conditional medical release statute?
Well, that's a terrific question, and we know that they have the medical records of the current inmate at the current facility. The records do go with the inmate when they're transferred from facility 1 to facility 2. So the current medical records for the specific inmate are at the facility. That doesn't mean that the loved ones shouldn't send in medical information, including a doctor's letter, immediately prior to when the inmate, to the extent this condition predated the incarceration, and I've had a few of those calls, and then it's gotten worse. It's not either or, it's both. So yes, the loved one is going to have to get a prior medical letter that was done either contemporaneously at the time a few years ago before the incarceration, or you can call a doctor who diagnosed the inmate before they went in, who then in turn can look at their records and going backwards can say, as of 2 years ago or 5 years ago, they had these conditions, to create the baseline and then to show how that condition either didn't exist but now does, or that condition did exist and it's gotten worse. As to how they can deny it and why they can deny it, again, if you look at that definition, there's some inherent discretion there. They simply may just disagree and not think, notwithstanding the inmate's belief or the family's belief, they may simply not think that the inmate is terminal based on their medical current diagnosis, or that they rise to a level of a permanent incapacity. Now, what do you do about that? If, in effect, what I think I hear them saying is, if the initial answer is no, you don't qualify, well, then you keep a log, you keep a chronology. Has the inmate's weight gone down? Are they having a hard time keeping food down? Have they lost some mobility? In other words, the practical conditions and consequences and symptoms of the chronic illness or disease, if it's in decline. This is what we did a few years ago to help an 80-year-old inmate. Originally, it was referred, but then denied. And then I went to see him, and the family kept updating more information. And then sadly, the inmate was getting worse, but we were giving almost real-time daily reports to DOC by email about how the inmate's condition was getting worse, because he was telling his loved ones by phone when he called and talked to them daily or several times a week, my condition is getting worse and here's how it's getting worse. And then the family member was writing the medical director and the warden with updated information. And in that case, we were able to get an elderly inmate out. He passed 10 days later, but the family members said it felt like they had 6 months with him, as opposed to just getting, even though it was only 10 days, as opposed to just getting a call, 2-3 days after the inmate passed at a prison in North Florida and not being able to see loved ones. So again, as much information as possible and essentially update it constantly if the inmate situation is getting worse.
Yeah, and so what I'm hearing, which I think is important, is that you need not only rely on what the DOC medical is saying, but rather you need to work with medical professionals outside of the prison to do their own independent evaluations of records, such that you can provide additional opinions, and in the hopes that DOC reconsiders their position.
Well, especially for the baseline, as to, in other words, what their condition was before they reported to the inmates' families will know this term. We have 5 reception and medical centers, meaning our 67 county jails in normal times every week or two are sending new inmates to those 5 reception centers, 4 for males in Miami, Orlando, Lake Butler, and Chipley, and 1 for females in Ocala. They process in from the county jails, and that's where at least DOC does the very first initial medical diagnosis, assuming it's the person's first time in state prison. If they're coming to state prison again for a second or third time, then there's the prior medical. But yeah, that's not mutually exclusive, particularly if the condition predated the incarceration. Then even before our list, the family member wants to get a letter from the private physician on the outside who had the most recent medical diagnosis of the inmate before he or she reported to state prison. I just happen to have a situation with a family member went back in December for violating conditional release. He has a very serious heart condition. So in that case, we'll be providing the private letters from the physicians who diagnosed his heart condition and surgeries prior to going back into prison 5 months ago, and provide that from the outside in, literally by snail mail, so that when the DOC officials look at, has he gotten worse in the last 5 months, they know at least as a baseline what his heart condition and situation was before he reported to prison 5 months ago.
Okay, so we have your additional steps here, the third and the fourth one, and I want to very briefly touch on those, because it seems like if you do have a medical diagnosis that fits now into the criteria within the statute, it needs to move from the prison to the Florida Commission on Offender Review. And so what are the mechanics on agitating to get it there?
Yeah, essentially, if you look at step number 3, it's really step number 1 on steroids again and again and again until you get at least some kind of response and hopefully satisfactory answer. So and then 4 is repeat, be polite, and be persistent. So really, it's you do steps 1 and 2 again in steps 3 and 4 until you get some kind of satisfactory response. And then don't give up. And then honestly, the first answer may not be the last answer. It may take DOC weeks or months to even do the very first diagnosis, and they may not think in their heart of hearts, based on objective medical diagnosis, that the inmate is terminal or permanently incapacitated. And the idea is, well, if they get worse, then and have an aggravating situation, especially if it's compromised by the virus, then how are we looking at it through that lens? So to me, it's almost an initial but ongoing level of communication and persistence that never stops until the desired result is achieved. And I don't mean that you have to email every hour, but I would email once a week. That doesn't mean you call, every day, but I would call 2 or 3 times a week. Just from a common sense standpoint, knowing that our wardens and our prison medical officials right now, they're as busy as they've ever been just doing the proactive mitigation CDC guideline steps to quarantine and isolate and test inmates. So on the one hand, it's more important than ever. On the other, it's more challenging, I would guess, than ever to get their attention because they're busier than they've ever been.
Yeah, and we have one more question, and we're approaching noon here, so we want to move towards wrapping up. But I think it's a good question. Carla writes, what percentage of inmates who are eligible for medical release, or the percentage of inmates who are eligible for medical release, is a drop in the bucket compared to the numbers they would have to release to effectively socially distance? You ask the question, why are we debating about something that wouldn't help much? And I think it's a good question, if for no other reason than to not sugarcoat any of this, right? Is that we understand at a baseline that the situation that is happening in prisons and will continue to happen as it relates to COVID-19 is not good and it's untenable, and that organizations like ours and other advocates, defender organizations around the country, National Association of Criminal Defense Lawyers, have been agitating more broadly for aggressive decarceration in order to allow for the people who remain to better protect themselves. When you put that aside, what we're trying to do here, I think, is give people a better understanding of the limited options that are available to get their loved ones out now. And those aren't going to apply to everyone. But these things are not mutually exclusive. We have our sort of broader policy objectives to keep all inmates safe, but then we want to try to give you some tips on what you can do for your loved one if they fall into these very narrow categories. I mean, do you think that's kind of where we're at?
That's exactly right. And thank you, Carla. On the one hand, we want to manage expectations. We don't want to give false hope. I will tell you, as a matter of hard data, in the last 24 years, there have only been 346 conditional medical releases, and that was before COVID-19. So 14 or 15 a year is, of course, a drop in the bucket out of 93,000 inmates. But for the one inmate, if there's one more that gets released or 10 more that get diagnosed because of this program and increased education by family members and inmates and advocates and legislators, in other words, every life is precious. And let's just think of the multiplier effect on this. There's a humanitarian angle to this to release the terminally ill or permanently incapacitated inmate so he or she can go home and finish their sentence, in effect, under confinement or probation. But there's also the impact on everybody else. If we release somebody who would have gotten the virus and was so vulnerable because of respiratory or lung or heart issues, and they in turn aren't there to get it and give it to more inmates and more officers who in turn give it to their family members, then we from a common sense standpoint know we've mitigated the spread by some considerable factor, but we can't test that negative statistic. So there's a humanitarian piece for the inmate and the inmate's family, but there's a more global systemic impact in that, even if it's just a handful more, ideally the more is better, but this is a continuing education effort for the policymakers and honestly for the DOC professionals themselves at the institution level to even know they have this power and discretion. I think they know they have it, but again, with everything else they have going, they're more likely to evaluate an inmate if the inmate and his or her family members are nudging them in that direction than if they're not hearing from inmates and families that somebody's potentially medically compromised.
Yeah, and so I'm going to wrap up with this one last comment. I'm seeing comments in the Facebook feed that a general frustration about the dysfunction that people experience within the Department of Corrections and about how ineffective the system is. I just want to say that we hear you. We have 40 clients who are in different DOC facilities, and like you, as family members, we struggle on a daily basis to do everything we can to protect them. Oftentimes with very little success. But the whole point of this discussion and future discussions is to try to give people, even amidst whatever dysfunction exists, opportunities to be able to help their loved ones. And we're going to continue to work to help our clients. And we know that people's loved ones are going to continue to work to try to keep them safe and hopefully get them released from prison. So Reggie, I wanted to thank you for your time this morning, and we'll let you get on with your Sunday. And I'm going to throw it back to Kelly to close us out. So thanks so much, Reggie.
My pleasure.
Thanks so much for sharing your expertise with us, Reggie and Seth. We will be linking resources and the steps from today on our website soon, so be on the lookout for those. Thank you all for joining us today. And before you go, I want to invite you to our next live talk coming on Tuesday. Tuesday afternoon, our intake coordinator, Dr. Adina Thompson, will be sharing some of her expertise on the factors that affect eyewitness misidentification and look at how Florida can protect the innocent from mistaken identifications. We look forward to some science, storytelling, and your time for questions. And also on Tuesday is the new Global Day of Giving called #GivingTuesdayNow. And just like our regular Giving Tuesday, which is around the holiday season, Giving Tuesday Now is not exclusively a fundraising day. It's an opportunity for people around the world and in our community to stand together in unity, to use their individual power of generosity to connect and to heal. So that's what we're doing here today, and we'll have more opportunities to get involved on Giving Tuesday, which is this May 5th. We'll be sharing ways you can express your generosity right from your own home and to keep in touch and keep helping our mission move forward to free the innocent. I'm Kelly Helm, and thanks so much for joining the Innocence Project for this Inside Innocence 3rd edition. Keep in touch using our newsletter online or follow us on Twitter, Instagram, or Facebook. Thanks again. Have a great day, everybody. Happy Sunday.